Hello, I'm Claudia Silva, the Director of the Office of Labor Standards and Enforcement. Welcome to the Working Families Ordinance webinar. Today, you're going to hear from staff about the background of the Working Families Ordinance. In addition, you will hear about the county construction bids pre-qualification process. County staff will talk about the applicability of the Working Families Ordinance to county construction projects, as well as to leases and lessee construction projects. We will also review the enforcement mechanism and provisions in the Working Families Ordinance and finish with closing remarks. In July 2021, the Board of Supervisors directed the Chief Administrative Office to develop a draft ordinance to set employment standards for county construction projects and construction projects on county-owned land. In addition, the Board of Supervisors directed the Chief Administrative Office to develop pre-qualification policies for prospective public works bidders. In October of 2021, the Board of Supervisors received the Community Feedback and County Staff Report, and they directed the Chief Administrative Office to engage a consultant to develop a Regional Economic Analysis and Impact Report. In February 2022, the Board received the Regional Economic Analysis and Impact Report, and here's community feedback on the draft Working Families Ordinance. The following month, in March of 2022, the Board adopted the Working Families Ordinance and bid pre-qualification process. The Working Families Ordinance became effective on April 1, 2022. It sets employment standards for county construction projects and construction projects on county-owned land that are valued over $1 million or over $25,000 where all work is performed by an apprenticeable occupation. On July 1, 2022, the bid pre-qualification process becomes effective.
My name is Rich McCarville. I'm Chief of Procurement Services here at the County of San Diego. I'm going to provide an overview and talk through some frequently asked questions as it relates to the new county construction bids pre-qualification process implemented due to changes to Board of Supervisors Policy F41. The County of San Diego Board of Supervisors on February 8, 2022 amended Board Policy F41, which relates to public works construction projects, to establish a requirement that all bidders on public works projects solicited after June 30th, 2022 be pre-qualified. The pre-qualification requirements do not apply to the extent to which they conflict with the terms of any federal or state grant programs, contract, or applicable law. The federal uniform guidance generally prohibits the use of standing pre-qualified lists. Some frequently asked questions. What process will be utilized to pre-qualify contractors? Pre-qualification will be conducted utilizing the county standard request for statements of qualifications process. When will the pre-qualification be conducted? The county intends to pre-qualify contractors via an RFSQ process quarterly. When it's determined to be in the best interest of the county may use a supplemental project-specific pre-qualification process for a particular construction request for bid. Factors informing whether such a decision to include the need for specialized or skills or experience will be considered in the determination of whether we do a supplemental project-specific pre-qualification process. Question number 3. If successfully qualified through an RFSQ process, for how long will pre-qualification be valid? Offers qualified via the RFSQ process, as described, shall be pre-qualified for a period of 1 year. Question 4. How will the county communicate which contractors have been pre-qualified? Offers qualified via either RFSQ process, either the quarterly process or the project-specific process, will be listed on the Qualified County Public Work Project Contractors List, which will be posted on the DPC website. This standing list of qualified contractors will be updated quarterly upon the conclusion of each subsequent pre-qualification RFSQ and as required. Contractors included on the qualified county list shall be qualified to bid on public works projects solicited during the effective period of the contractor's qualification.
Hello, I'm Bill Morgan with the County of San Diego Department of Public Works. I will be covering aspects of the Working Families Ordinance that are applicable to county construction contracts. Section 7310 was added to the County Code of Administrative Ordinances to provide employment standards for county construction projects. The new ordinance requires that contractors and their subcontractors at any level that perform construction on a project that was awarded by the county with a contract value greater than $1 million or over $25,000 where all the work is performed by an principal occupation, comply with specific requirements related to workforce qualifications, employee leave, and employee protections. Violations of Section 7310 may be reported to the County Office of Labor Standards and Enforcement. I will address each of the new requirements on the following slide, but first wanted to share that there are certain limitations to the scope of Section 7310 that are important to note. Specifically, the ordinance will not apply irrespective of the contract value if prohibited by law or if prohibited by state or federal funding source requirements applicable to the work. The ordinance will not apply to county job order contracts or housing projects that were entered into prior to the ordinance effective date. The ordinance will not apply to agreements with other agencies or public utilities or to firms that employ 20 or fewer employees for each working day in each of 20 or more weeks in the prior 12 months. And finally, the ordinance will not apply to projects where an applicable collective bargaining agreement, including a project labor agreement, specifically supersedes the ordinance, or where the Board of Supervisors has waived all or a portion of the requirements in regard to a particular project. As noted on the prior slide, Section 7310 requires that contractors and their subcontractors at any level that perform construction on a project that was awarded by the county with a contract value greater than $1 million or over $25,000 where all the work is performed by an principal occupation shall follow minimum standards. These minimum standards include Section 7310A of the ordinance states that contractors and subcontractors shall utilize skilled and trained workforce as defined in Public Contract Code 2601D. You're encouraged to review the referenced Public Contract Code, California Labor Code 3075, and other sources of relevant information regarding the conditions that must be met to adhere to the referenced code. Section 7310B of the ordinance requires employees to provide paid sick leave to cover, at a minimum, absences for 6 specific categories as applicable to the employee and their family. Section 7310C of the ordinance requires employees accumulate sick leave at the rate of 1 hour for every 30 hours worked, with a minimum cap of 48 hours per year. Section 7310D of the ordinance states that an employer on a county construction contract not discharge or discriminate or take any adverse action against an employee for discussing the terms of their employment. Section 7310E of the ordinance states that an employer on a county construction contract shall post information regarding the requirements of the ordinance and shall post the method and contact information for reporting violations to the County Office of Labor Standards in an obvious, visible, and accessible place. And finally, Section 7310F of the ordinance again states that the ordinance shall apply equally to all contractors and subcontractors, shall be included in all contracts and subcontracts, and shall apply even if it was not included in those documents. Included on this slide are several frequently asked questions, as well as references to access applicable documents. We encourage you to review Section 7310 of the County Code of Administrative Ordinances. Thank you for your time.
The County of San Diego has many departments who lease property to others. Airports owned properties are leased and managed through the Department of Public Works Airport Section. All other county leases are managed by the Department of General Services. Beginning April 1st, 2022, all new leases of county-owned property and leases amended for reasons other than for scheduled changes in rental rate or compensation will be subject to the Working Families Ordinance. This ordinance also applies to new leases effective prior to April 1st, 2022, where explicitly agreed to by the parties. Once a lease is subject to the Working Families Ordinance, the lessees, their sublessees at any level, and their licensees at any level must pay prevailing wage rates and utilize a skilled and trained workforce for any construction projects meeting the specified thresholds. They must ensure facilities and property meet the requirements of county ordinances or board policies regulating workplace conditions. They must provide specific sick leave to their employees working on or from the leased premises and must not discharge or in any way discriminate or take adverse action against any employee for disclosing a concern about the terms and conditions of employment. And finally, they must post notices regarding the Working Families Ordinance. These requirements shall not apply to the extent prohibited by law or by state or federal funding source requirements. Specific projects may be exempt from these requirements if 1. There is a job order contract for the construction or where a collective bargaining agreement or project labor agreement specifically supersedes the ordinance. 2. For housing projects where the county received the underlying proposal or entered into the agreement for the project before April 1st. Or 3. Where the Board of Supervisors has waived all or a portion of the requirements for the project. Leases for the placement of equipment or other personal property, or for other purposes involving no regular occupancy by individuals, are exempt from the requirements of the Working Families Ordinance. The following lessee parties are also exempt from these requirements: certified disadvantaged business enterprises during the first 3 years of a new lease or contract, 501c3 organizations whose highest paid officer earns a salary that when calculated on an hourly basis is less than 8 times the hourly wage of its lowest paid employee, government agencies or public utilities, firms employing 20 or fewer employees each working day in each of 20 or more calendar weeks in the prior 12 months, where employees and contractors providing ancillary services work on the county-owned property for an average of fewer than 8 hours a week in the prior 12 months, or if waived by the Board of Supervisors. If a lessee is subject to the requirements of the Working Families Ordinance as described above and does not qualify for an exemption, they are required to pay prevailing wage on all construction projects valued over $1 million. These construction projects may not be split for purposes of avoiding the $1 million threshold. They are also required to use a skilled and trained workforce as defined in Public Contract Code Section 2601D for all construction projects valued over $1 million. Or over $25,000 where all the work is performed by a single apprenticeable occupation. Under the Working Families Ordinance, non-exempt lessee parties and their contractors must provide employees working on or from the county-owned property with paid sick leave at an accrual rate of 1 hour for every 30 hours worked, with an accrual cap of 48 hours per year. The sick leave must cover, at a minimum, absences due to all the defined minimum qualifying circumstances included in the ordinance, as related to illness, injury and health condition, or resulting from domestic violence, sexual assault, or stalking. Lessees and contractors subject to the requirements of the Working Families Ordinance must place notice regarding the ordinance in a conspicuous and accessible place in each location where employees work. This notice must provide a summary of the ordinance requirements and information for reporting violations. The following are frequently asked questions regarding lessee construction projects. First, are all construction projects on county-owned leased land required to pay prevailing wage rates and use a skilled and trained workforce if meeting the thresholds? The answer is no. Construction projects meeting the thresholds only need to comply with the Working Families Ordinance requirements if the associated lease was created or substantively amended after April 1st, 2022, or if such lease explicitly requires compliance with later enacted county ordinances or policies related to employment standards, and if there is no applicable exemption. Secondly, what documentation is required to prove a lessee is complying with the Working Families Ordinance? Applicable lessees must self-certify whether they qualify for an exemption and will be required to maintain records sufficient to document their compliance with the Working Families Ordinance and provide such records to the county upon request.
Hello, my name is Brandon Butler. I'm the Deputy Director of the Office of Labor Standards and Enforcement for the County of San Diego. And today, I want to talk to you about how enforcement of the Working Families Ordinance will operate. Let's begin with a frequently asked question. What is the San Diego County Office of Labor Standards and Enforcement? Well, the San Diego County Office of Labor Standards and Enforcement, otherwise known as the OLSE, provides outreach and education to advance labor standards in San Diego County. OLSE also enforces labor standards designated by specific county ordinances. To learn more about the OLSE, please visit the website you see below. Our next frequently asked question begins with what happens if a complaint is filed by the public or an employee alleging the employer violated the Working Families Ordinance. Well, the San Diego County Office of Labor Standards and Enforcement will conduct an initial investigation to determine if the complaint is meritorious. The investigation may include interviewing employees, employers, third-party witnesses, reviewing documents, or other investigatory tools depending on the nature of the complaint. If it is determined by OLSE that a violation occurred, OLSE may require immediate correction of the violation, issue citations, impose civil penalties, or use injunctive measures designed to secure compliance with the Working Families Ordinance. Our next frequently asked question is, what is the penalty for failing to comply with the Working Families Ordinance? The County Code of Regulatory Ordinances provides for a range of penalties for failing to comply with a county ordinance. Penalties may include citations, civil penalties of up to $1,000 per day, or injunctive remedies, such as a stop work order. Additionally, contractual remedies may apply. In certain situations, an employer alleged by the OLSE to have violated the Working Families Ordinance may request a hearing conducted by a county hearing officer to contest the issuance of the violation or penalty. Our next frequently asked question is, can an employer discipline an employee who made a complaint to the San Diego County OLSE alleging concerns with the terms and conditions of employment, but that was later dismissed by the OLSE? Well, the answer is no. Retaliation, discrimination, or harassment against an employee who raised concern about the working conditions is unlawful and violates the Working Families Ordinance, as well as other related state laws. Even if the complaint of the employee is not substantiated or is later dismissed, an employer cannot retaliate against the employee under the Working Families Ordinance. The County of San Diego is committed to providing educational resources to assist the public in understanding the requirements of the Working Families Ordinance. First, the OLSC website is the central hub to obtain educational resources about the Working Families Ordinance. There you will find the required notices that employers must post at the worksite. You'll find flowcharts that explain the Working Families Ordinance. You'll also find a copy of this webinar and frequently asked questions about the Working Families Ordinance. The OLSC website also contains informational resources, such as a copy of the ordinance, the board letter that put forth the Working Families Ordinance, and the self-certification exemption form if you're an employer that is exempt from the Working Families Ordinance requirement to fill out. And remember, please contact OLSC if you have specific questions or if you'd like to file a complaint related to your rights under the Working Families Ordinance. You can contact and reach the OLSC at 619-531-5129, or you can email us at olse@sdcounty.ca.gov. On behalf of the County of San Diego, we thank you for taking the time to watch this training about the requirements of the Working Families Ordinance. And together, we will create a culture of labor standards compliance and workplace safety. Thank you.